We're going to be a little bit, because I've got to do the jury instruction. It'll be a little while. Okay. No rush, in other words. Mr. Williams, I can print them out for you if you need something. Okay. If Fran needs a copy, I can print it. No, I went back to bed. I wake up in the middle of the night a lot and work and go back to bed. I used to be able to run on 5 hours of sleep without any trouble. Now I'm getting a little more than that I need, but doesn't bother my wife at all. She just sleeps through it. I was supposed to be.
They said till 10:30. Maybe Rikers Island. Oh, you missed.
Sue, you ready to go on the record? All right, let's go back on the record if we can. We have to finalize jury instructions and verdict form. We worked on them last night. We have been off the record for the last few minutes on these matters. Mr. Williams, do you want to bring us up to date on the jury instruction, where we are with regard to agreements and where we do not have agreements?
Yes, Your Honor.
I spoke to counsel, and it's my understanding that defense counsel is going to agree to the suggested language under felony murder, where it states in red in the copy that I sent last night, interlocking counts. Does Your Honor have that in front of him?
I do.
I think there's an agreement that that is an acceptable instruction and statement of the law.
Is that acceptable?
That is correct.
Okay.
The only other changes that the state has made, and I didn't discuss this with Mr. Inako knowing this conference was coming, is I took out of red and put into black defendant not testifying, and I removed the two sentences about the defendant has become a witness,
Okay.
given Mr. Okafor's decision. Other than that, I believe there were no other disputes regarding the instructions, and that they are now finalized subject to defense counsel's objections and renewing of objections.
And the burglary definition that follows the 7.3 felony murder first degree was modified as a result of the conference last night, and you have put the court's ruling in that in there. Is
That's
that
correct.
Okay, and I understand you're still in objection.
I am still objecting to that, Your Honor, and I didn't discuss it with counsel because I didn't realize it at the time, but the count 4 burglary instruction still identifies the offense as simply other than burglary or trespass in the structure, so it does not specify an offense, and it is different from the offenses that are specified in felony murder burglary instruction.
Trying to get to it. Oh, I see it. I'm going to let Mr. Altman and Mr. Williams look at it.
Oh, I'm sorry. What were you looking at before? I have no idea what you're looking at. So with the general ask for multiple pages. Let's see, I didn't think we were going to have a separate instruction on the blocking counts. I thought the only place it appears. I don't know, yeah, but we shouldn't have that. I mean, I thought it was going to be in the felony murder instruction. I thought it was going to be. I thought it was going to be. Yeah. Without defining it. It was going to be part of the, well, all right, I guess it doesn't really matter. It's not part of the felony murder instruction. That's what I thought it should be. Well, what it is, because all these things are classified as separate. No, remember that this instruction says you have don't have a separate principal instruction. Oh, really? That's the same thing, right? Oh, okay. All right. Okay. All right, so I'm sorry. What are we looking at?
One moment, Judge.
Yes, sir. That's okay.
Yeah. Oh, some burglaries. Yeah, they want it. Your language is alleged. Right. They want
Got that address report?
Let them, they're talking right now, so they can't hear us, so let's let them finish what they're doing.
Thank you.
Okay, that's fine.
Your Honor, state agrees to put the exact same language from the definition of burglary that's included in felony murder into the language from count 4.
Okay, and you want that language, you don't want the other paragraphs in there that we deleted out of the first
Correct.
word.
The only change, my understanding is the only change counsel is requesting at this point is that the burglary for count 4 reflect the list of offenses that the felony murder burglary instruction contains, and we are not objecting to that.
You don't need the definitions of firearm and the
Oh, no, I'm sorry, Judge. Yes, all those are included in count 4 burglary.
That's what I thought.
Yes, Your Honor.
And I think Mr. Anaku's position is that the definition of burglary that you have under felony murder is different than the definition of burglary that you have under this count 4. Is that correct? Or did I misunderstand you?
The underlying offense was different. They're now indicating it's the same. I still don't believe that they can just list basically any offense under the sun as the potential underlying offense.
My question is, my understanding is you have an objection to the burglary instruction under count 4. So maybe the best way to ask it is, what is your objection to the burglary instruction under count 4 as it's set out?
My initial objection was that it did not specify an underlying offense. It now uses the same approach as in the felony murder instruction, which is to list every possible offense and every possible lesser offense.
Okay. Let me get back to it here. I must be missing something. Let me have both counsel approach for just a moment. forgot to remind me, Sue. You get so used to it, you don't even notice it's on.
Your Honor, how many copies? I was going to say at least 22. Yes, Your Honor. Please. Sure.
Your Honor, while we're waiting, I have discussed the jury instructions with Mr. Okafor, and there's nothing else that we need to discuss or present to the court. He's in agreement with that.
Mr. Okafor, let me ask you a couple of questions if I can, sir. I know you were here last night when we went over jury instructions and worked with us for a while on that. There's been a little more work done this morning on them to finalize the jury instructions and the verdict form. Have you had a chance to discuss that with both Mr. Mosley and Mr. Naku in this matter? And you understand that those are the jury instructions that we're going to be utilizing with this jury? And those are the verdict forms you're going to be utilizing? Okay, thank you, sir. I just wanted to make sure you had input on that. Thanks.
Your Honor, I sent the email to my office and I copied, Your Honor. If you wouldn't mind double checking the copy that I sent to make sure it's right.
Your knowledge, these are the updated ones.
To my knowledge, yes, they are. That's, but I'm putting it on, Your Honor, to make sure I'm right.
about ready, or do you need a few more minutes?
About 5 more minutes, Judge. Thank you.
I don't see the special findings attached.
There are no special findings, Judge. There was a waiver earlier, I believe.
Just 4 verdict forms.
Yes, Your Honor. What do you think, Sue? Can you hear me? Thank you, Judge. State's ready.
All right, you're there. Yes. Please be seated. Welcome back. Thank you for coming back. A couple of you look like you may be a little chilly. Jeff has some more shawls over there. If you need them, just let him know, and we'll make those available. As you heard, both the state and the defense have rested their case at this point. The items remaining are the closing arguments and the law. We are going to start with some closing arguments in this matter, and then give you the law after that. Each side has an opportunity to present a closing argument. The state will make the initial closing argument, then the defense will have a chance to respond, and then the state will have a concluding closing argument. We will give you the jury instructions also. We are ordering your lunch. As you saw, it was nothing fancy. It's not the Ritz-Carlton, but it makes it easier for you time-wise to be able to eat back in the jury room. So probably by the time it gets here, which is probably going to be about 1 o'clock, maybe a little bit after for the lunch hour, we'll be able to take a break at that point, let you have lunch, and then we'll finish up, and then we'll be turning the case over to you in this matter. Let me ask you about pads. Does anybody need another pad? Are you running low on paper? You're running low on ink? Looks like you've got enough pens on the rail. Anybody? Okay, if during the closing arguments you run out of paper and need one, just raise your hand. Again, you've been very good about telling us if you can't see or can't hear. The attorneys need to know that, so please let them know that. Remember, what the attorneys say in closing argument is not evidence, but it will be extremely helpful to you in this matter. Mr. Williams?
Thank you, Your Honor. May it please the court,
Yes, sir.
counsel. Ladies and gentlemen, it is the nature of miracles that they come as a surprise. We commonly refer to miracles because our knowledge of the circumstances surrounding certain events indicate that they shouldn't happen the way they do. We look at a set of circumstances and we say, this is what the outcome should be. But sometimes fate or divine intervention, whatever you believe, steps in and changes that event and that circumstance. That is what we have here. The lives of Brianna and Remington Campos, their very presence in the courtroom today, those are miracles. It is a miracle that they survived being lined up on the floor of their own living room and shot in the back of the head. But the evidence in this case goes much further with that miracle. The evidence in this case tells of a miracle that is much more powerful still. Because while it is a physical miracle that those two people, those two young people, survived the gunshot wounds, it is a larger miracle that they survived the plan that led to them. The evidence that you've heard over the course of the last 3 days indicates that that plan, Bestman Okafor's plan, was set in motion and was a well-orchestrated attempt to end their lives, to prevent them from ever coming here. Unfortunately, September 10th, 2012 is not merely a story of miracles. Because as you've heard, there was no miracle for Alex Zaldivar. So for the next few minutes, we're going to talk about how Alex Zaldivar's life ended, not in a miracle, but at the hands of a detailed plan set in motion by the defendant, Bestman Okafor. And as we move through, there will be no doubt, let alone a reasonable one, that he is responsible for Alex Zaldivar's death. So let's talk a little bit about the evidence in this case. And we're going to talk about the evidence in terms of the elements that the state has to prove to you to prove the crime of first-degree murder. The first element that the state has to prove is that Alex Zaldivar is dead. I do not believe there will be any dispute about this fact. The unfortunate reality is that the medical examiner, Marie Hansen, Dr. Marie Hansen, testified that she performed the autopsy on Mr. Zaldivar on September 11th, and that he died as a result of 2 independently lethal gunshot wounds to the back of his head. Leaving aside, of course, the testimony from Remington Campos, who laid next to Alex Zaldivar as he took his last breaths. So the first element the state has to prove is that Alex Zaldivar is dead, and I do not believe there will be any dispute about that. The second element the state has to prove is essentially who did it. That not someone killed Alex Zaldivar, but that Bestman Okafor, the defendant in this case, killed Alex Zaldivar. So we're going to spend an extended period of time talking about all of the evidence that has done that and proven that very fact. The first piece of evidence or portion of evidence I'd like to talk to you about is the home confinement evidence in this case. You heard from 3 separate witnesses who worked in and around the home confinement system in Orange County back in September of 2012. Chris Poole works for 3M and told you about how the monitor worked. Meg Hughes was Mr. Okafor's supervisor, and Kenya Cox went out as the field person responsible for watching Bestman Okafor. We know, based upon the facts, that Mr. Okafor was on home confinement as a result of his going into the home of Alex Zaldivar, Brianna Campos, and Remington Campos on May 9th of 2012.
You may.
As I said, we know the defendant was on bond and home confinement as a result of his actions on May 9th of 2012. Mr. Poole testified that the maximum limit for that device, which he sold and routinely used, was 150 feet, maximum. Recall his testimony was that depending upon environmental factors, was his word, walls, trees, it was somewhere in the range of 75 to 100 feet. Ms. Cox testified that the device was set up inside Mr. Okafor's kitchen, and while there was testimony that in the first 2 or 3 days, so back in June of 2012, 2 months prior to the murder, there were problems with Mr. Okafor's device, there were no such problems following that. Mr. Poole testified about how an ankle monitor is placed on the suspect or the defendant's ankle. That monitor you heard from Ms. Hughes was placed on Mr. Okafor's ankle, and when that maximum limit is exceeded, a loud beeping sound ensues. In fact, you heard today from Ms. Hughes a few minutes ago that family members of defendants would call because the loud beeping was so loud, leaving no doubt that when a person is away from that residence and away from that box, it is known. And Ms. Hughes testified that she never heard of any complaints about that device not working for Mr. Okafor after the first couple of days. Ms. Hughes described, and now in evidence are reports that document the occasions when Mr. Okafor, according to his monitor, was not at his home. And I draw attention to the arrow marking the violation of curfew on the list, marked at 4:40 and 43 seconds a.m. until 5:46 and 39 seconds a.m. Because I hearken you back to the testimony from one of the first witnesses, Officer Schilling, who said that the 911 call for the shooting at 503 Bernardino Drive came out at 5:24. That is 1 hour and 6 minutes that Bestman Okafor left his home to carry out the murder of a 19-year-old young man. Documented with a device on his ankle that, according to the witnesses, was properly functioning that day. There's no way around it. We also know that that monitor was working because it's been challenged that it might not have been functioning properly because of the other curfew incidents listed on that document. There was one at 3:49 a.m. on the same morning where Mr. Okafor was away from home. Well, we know what that was because we have the testimony from Sharia Gordon, who said that around 3:50 in the morning, and according to her phone records, it was precisely at 3:52 that Mr. Okafor left St. James Place and drove to pick her up. Therefore, there is no doubt that the home confinement record in front of you is accurate because it's verified by other testimony. And there's further testimony that establishes that his monitor was working that night. Because recall, Ms. Hughes told you that on September 10th, after he left and fled his 3 o'clock appointment, she and another home confinement officer went and waited at Mr. Okafor's home. And what did she say she saw that evening around 7 o'clock? Mr. Okafor running away. And there it is in black and white, documented in the paperwork. At 7:19 p.m. to 7:56, he was away from home, just as Ms. Hughes said. So the paperwork not only verifies that he was away from home and that it was functioning, the device was functioning properly, but it verifies Ms. Hughes' testimony. And ladies and gentlemen, as we move through the evidence in this case, you're going to hear that a lot. Because it's not one single piece of evidence that proves beyond a reasonable doubt that Mr. Okafor murdered Alex Zaldivar and tried to kill 2 more people. It's that all of those pieces fit together seamlessly. One proving the other, verifying the third, over and over. At one point, defense counsel asked the witness, well, it's possible somebody could be in the yard. Mr. Okafor was in his front yard at 4:45 a.m. for an hour and 6 minutes on a random Monday morning, the day before his trial was supposed to begin. That is what has been argued to you. Home confinement, that's one piece of evidence, or one part of the evidence why we know Bestman Okafor murdered Alex Zaldivar. We also know that from the victim accounts in this case. We'll start with the testimony of Remington Campos. He told you that on the morning of September 10th, he was asleep in his bed when a man he described as stocky, with short dreads or twists, entered his bedroom and pulled him out of his bed. We now know, based upon the evidence, that that man was Donnell Godfrey. Short, stocky, twists in his hair, just as described, because he did not make an attempt to cover his appearance that morning. It was dark, and Mr. Campos acknowledges he can't identify the face, but the appearance matches the associate, Donnell Godfrey, of Bestman Okafor. Also, extremely significant from Mr. Campos' testimony is the firearm that Mr. Godfrey was carrying, because he told you that he is familiar with and owns a Glock firearm. It's a semi-automatic, and he described the special polymer that is on the outside of that firearm. And he said he saw it and he knew what it was. Because we're going to come back to that here in a moment when we talk about the evidence, the forensic evidence from the case. Moving forward, Mr. Campos described to you how he was dragged out of his bedroom through the hallway and through the kitchen into the living room where his sister and Alex waited. And what did he say he saw as he went through the kitchen? A taller, thin, black male with an assault rifle and long dreads. So like all the other evidence in this case, one piece of testimony corroborated by another. I give you Emmanuel Wallace in October of 2012 as testified to by Detective Mareshi, and what is found in his home near paperwork belonging to him, but a magazine that Christine Murphy testified goes to a rifle, a .223 as she described it. All the pieces fitting together, giving you confidence in exactly what Mr. Campos said happened that morning. So then we turn to the very detailed, if not harrowing, testimony from Brianna Campos. So what did Ms. Campos told you? She told you that a taller, lanky-looking individual, she acknowledged under baggy clothes, wearing T-shirts on his face, with a low-cut haircut, came into her bedroom that morning after she heard the dogs barking and was trying to get dressed in a panic. We know that that person was Bestman Okafor, not just because he matches the physical description given, particularly in comparison to the other two individuals who look totally different based upon their hairstyles and builds, but because of what was heard as she was lying on the floor in her room, in her living room. Who's the naked guy? Remington Campos was not identified by the suspects because Bestman Okafor didn't know who he was. Because the only time Bestman Okafor had been in that house, he wasn't there. Because you have to remember that as of May 9th, he was expecting to find certain people. Because Bestman Okafor went there for a certain purpose. And Remington Campos wasn't part of his plan. And we know that based upon his statement, who's the naked guy. We also know that Bestman Okafor was the individual talking, the individual that eventually fired the firearm that morning, because he asked, where are the other two? Because you've heard testimony that two of the people present on the May 9th, 2012 home invasion were not there that night. Ladies and gentlemen, there is no way zero way for anybody to make those statements and know that information unless they were there before. It is logically impossible. And it is proof that Bestman Okafor is the man behind the revolver that morning. So, combined between the two of them, Mr. Remington Campos and Miss Brianna Campos, 3 suspects identified, 2 with distinct descriptions from Remington Campos, the 3rd with a different description from Brianna Campos, matching the 3 suspects that all the other evidence and testimony in the case has said were the ones in the Impala driving to that house. Donnell Godfrey, Emmanuel Wallace, and Bestman Okafor. So, now we get to the point of their account where they are shot and young Alex Zaldivar loses his life. And the question is posed, who fired the shots? Well, first of all, under the law, it doesn't matter, because there's an instruction you're going to receive called principle. And what it says is that if those people present, all 3, had the conscious intent that the act occur, the murder, then it doesn't matter if they actually performed it. They are equally responsible under the law. So that's the first thing. But I would submit to you that that doesn't matter, because you know exactly, according to the evidence, who the shooter was. You know that it was Bestman Okafor based upon the forensic testimony and the testimony of Remington Campos. He told you that Donnell Godfrey had a Glock firearm. That is a semi-automatic firearm he's familiar with. You heard from Christine Murphy that a semi-automatic firearm ejects shell casings out when it fires. There were no shell casings found, according to Karen Livengood, the CST. We also know that Donnell Godfrey and Emmanuel Wallace didn't fire the shots because Christine Murphy compared the bullets to one another. And she testified to you that the projectile found in the floor, the projectile found in the coffee table, and the projectile removed from the head of Alex Zaldivar were all fired from the same gun. And she specifically told you that a Glock firearm did not fire those projectiles. It was not a rifle projectile, according to her testimony. It was a revolver. We know that because there were no shell casings found. We've eliminated Donnell Godfrey. We've eliminated Emmanuel Wallace. And there was one man left who could have fired the shots, who did fire the shots. Which is not surprising when you consider that he is the man with the motive to do the killing. The victim accounts in this case not only prove that Bestman Okafor murdered Alex Zaldivar, went into their home, but that he is the shooter. So how else do we know that Bestman Okafor is the murderer in this case? We know that because of the relationships all the parties had. When you go back and review the testimony in your mind of all the people involved in this, there is one common link to every individual, and that link is Bestman Okafor. Emmanuel Wallace was a friend to the defendant and the brother of Pearl Wallace, who had a child with Mr. Okafor. He is the link. You further know that Mr. Wallace was involved because he was present at 4117 Maple Grove Court on May 9th when Mr. Okafor was arrested for the first home invasion. Another tie between the 3 individuals who went into the house that morning. That was the testimony from Officer Wagner. Donnell Godfrey was an associate and friend of Bestman Okafor. We know that he's the common link because Sharia Gordon didn't know who Donnell Godfrey was. 2 complete strangers. In fact, if you recall her testimony, she called him Darnell. She'd never seen him before, but she could describe him. That's because it wasn't a tie to Sharia Gordon or to Nestle Cicerone. It was a tie to Bestman Okafor. Mr. Cicerone, same thing. He's a friend of the defendant, casual acquaintance with Mr. Godfrey, playing basketball, and Mr. Wallace. And then, the most convincing relationship of all is Sharia Gordon. 7-month pregnant Sharia Gordon, out on the side of White Road on the morning of September 10th, 2012. The one link who doesn't fit, except for her relationship with Bestman Okafor. There is no reason in the world for Sharia Gordon to have been there that night, except that she was trying to help the father of her children. The relationships between the 5 people in this case prove that Bestman Okafor is the murderer. Then we move to the witness accounts in this case. And I would submit to you as we go through the witness accounts that these accounts by themselves, without anything else, are more than enough to convict Mr. Okafor of first-degree murder. And we'll start with Sharia Gordon. Sharia Gordon testified. She came in here in her jail clothes with her handcuffs on, and she told you that, or you heard that she has entered a plea agreement in this case, and it will be argued to you that she is lying because she wants to get a favorable deal. So this is what I will tell to you about Sharia Gordon, and Nestle Cicerone for that matter. Only accept the portions of Miss Gordon's testimony that are corroborated by something else. Only believe the things that Sharia Gordon tells you that somebody else verifies. And if you do that, you'll believe almost everything she says. Because you'll receive an instruction about that. There's going to be an instruction that the judge is going to give you that talks about witnesses who get the benefit of a deal. And it tells you should be specifically concerned if there's nothing corroborating, but that is not the case with Miss Gordon. So let's talk about the corroborating evidence. Miss Gordon said that she received a call from Bestman Okafor on the morning of September 10th, and that he called her and he was coming to pick her up. We know that because her phone records and the phone records of Bestman Okafor verify that phone call occurred. We also know that she's telling the truth because the cell phone maps and evidence from Mr. Fleck said that when she received that call, she was bouncing off a tower that was consistent with her being at home. Her home was within the coverage area that morning. We know that Miss Gordon is telling the truth because she said she loaded up her children, went back to Mr. Okafor's residence, and then they went to pick up Nestle. And that she told you after they picked up Nestle they had to stop for gas. How do we know that's true? Because there's video evidence of it. At 4:45 in the morning, at 8299 Silver Star Road, a very clear video with Takithia Ruffin's white Chevy Malibu, missing the passenger door handle, pulling into the Marathon gas station, followed shortly after by Tony Nelson, the friend of Mr. Cicerone's Taurus. She said she stopped for gas, and there's the video proving it. She said that shortly after the gas station, they went to a vacant house. And that is where they met up with Mr. Okafor's sister's Chevrolet Impala. And who did she say was in the Impala? Emmanuel Wallace and Darnell. The same 2 people who matched the description of the victims in their home. We know that they went to the vacant house in between the gas station and the murder because the traffic camera at White Road picks them up in a time frame that is exactly consistent with it. At 5:01 and 30 seconds on that camera, you see the beginning of all 3 vehicles driving westbound to an unsuspecting Brianna Campos and her brother and Alex Zaldivar. Everything she says corroborated by video. Let's just be clear about that, by video evidence. She said she waited out on White Road for a while, which is also consistent with Miss Accurena's video from 630 Butterfly Creek, because in that video you see two vehicles. Because remember, she testified she didn't go any further than White Road. She stopped. Because in that video we see two vehicles. One is Nestle Cicerone, who says he stops in the park. And in the video, the park is exactly where the maps show it is, where Detective Mareshi testified to where it was. And then you see the Impala with the three murderers driving past at 5:06 a.m. Miss Gordon says she waited on White Road and they traveled back to the vacant house, and we know that to be true because the traffic cameras caught them on the way out only minutes after Alex Zaldivar lost his life. And of course, at the end of the video, the police cruiser comes in. Nestle Cicerone also testified, and his testimony was virtually, not all, but virtually identical to Sharia Gordon's, which is important because I asked Detective Mareshi during his testimony, did you ever tell one what the other said? Because sometimes detectives will do that to prompt a statement to get people to start to tell the truth. And what was his answer? No. Two people, never having spoken to one another about this, according to the evidence, not told what the other one said, and they gave the same version. The exact same version. That is beyond coincidence, ladies and gentlemen. And Nestle Cicerone's testimony is corroborated in the same ways that Sharia Gordon's was. Now, I want to stop for a moment because this morning you heard that Nestle Cicerone, according to the defense, is the murderer. And obviously Nestle Cicerone did not say he's the murderer. He was, according to the evidence, forthright. He came forward and said, yes, I was there. Yes, I've pled. Yes, I'm facing significant time in prison for what I did and what I knew. And I would submit to you at this point that the idea that Nestle Cicerone is the murderer in this case makes no sense whatsoever. Let's start with the fact that Nestle Cicerone had no motive whatsoever to go to that house, as opposed and completely in opposite the defendant Bestman Okafor. But the larger reason that we know Nestle Cicerone is not the murderer is because he volunteered the information. And why do I say that? There was no independent evidence that could have put Nestle Cicerone at the scene. Because remember, he didn't have his phone. Everyone else's phone was there. Nestle Cicerone came forward and said, I had Emmanuel Wallace's phone because Bestman Okafor gave it to me at the house. He even described what the phone looked like. Emmanuel Wallace's phone with the purple cover. If Emmanuel Wallace wasn't involved, all he had to do was say, I'm not talking to you. My phone's not there. My phone's at home. And Mr. Fleck verified that. There was no activity on Mr. Cicerone's phone. But all that does is verify exactly what he said. There was no activity because he hurriedly got into Tony Nelson's white Ford Taurus at Mr. Okafor's request, leaving his phone behind. Then we move to Antoine McLaren. Mr. McLaren reluctantly took the stand, told you that he was a friend of the defendant, Bestman Okafor, told you he was here not because he wanted to be, but because he was subpoenaed and ordered to be here. And he told you that he received some text messages from Bestman Okafor. And more importantly, for our present purposes, he told you about a conversation that Mr. Okafor had with him on September 9th of 2012, not even 12 hours before the murder. He told you Bestman Okafor was concerned about his case, that Mr. Okafor wanted him to go get a hoodie and gloves, and most importantly, Mr. Okafor told Antoine McLaren he could not let the witnesses show up. The next type of evidence that verifies that the defendant, and leaves no doubt that the defendant is guilty of first-degree murder is the digital forensic evidence in this case. You heard testimony from Detective Ed Michael, and he talked about all the evidence that gives him confidence that the phone number associated with Bestman Okafor, that phone was the one he was using that night. Because there's been talk about, well, several people used the phone. Detective Michael said that the email accounts associated with the phone were not only Bestman Okafor's, but they had his name within the accounts, that the Facebook status on that phone belonged to Mr. Okafor, that there were selfies of Mr. Okafor within the phone at the time. And then we have the content of the text messages themselves, which verify that that phone was in the possession of Mr. Okafor at the relevant times. Because not only do we have all that evidence that's his, but on September 9th of 2012 at 5:29, he's texting with Antoine McLaren, can't text about my case. Did somebody else have a case that was waiting the next day? The only other person was incarcerated, Nolan Bernard. Bless you. So that's how we know that the content of the messages verify Mr. Okafor's possession of the phone. Going further down, as we move through September 9th, Sunday, at around 9 p.m., and this verifies with Antoine McLaren's testimony that he's getting text messages, Mr. Okafor wanting him to go and pick up items for him. He's vague in the text messages, which we know he knew to be because he said he couldn't text about specifically what was coming. And by the way, we also know that Mr. Okafor was aware of that because he deleted all of these text messages. Remember what Detective Michael testified to, that when he first got the phone, all of the messages had been deleted. It made him suspicious and he found them. And in the law, we call that consciousness of guilt. Because Mr. Okafor knew there was a chance they would be coming for him, and coming for him, and come for him, they did. Then, we also have the text messages on the phone that go to motive that we'll talk about in a moment, because Mr. Okafor had more than a hunch that Brianna Campos and Remington Campos were going to cooperate with the law to see that justice was done. He knew. How do we know he knew? Because his lawyer told him. And that gave him concern that someone might come in and tell the truth about what he had done. They say all the witnesses gonna show up. The next type of evidence is the cell phone records. Agent Fleck came in and testified about his being a member of the CAS team, and he told you in great detail, which I will not repeat, about how cell phones work, which all makes sense with our common everyday experience with cell phones. That there are towers, that the cell phone companies arrange those towers in ways that make sure we don't drop calls and they don't lose customers. He told you about his training from the engineers who put those towers together. And most importantly, he told you the position of all 4 cell phones that night. And ladies and gentlemen, I ask you to take a very close look at the document in front of you. 4 phones identified with 4 of the 5 suspects in this case. In a 4 people associated with Mr. Okafor at a location that they had no reason to be at, because that shouldn't be lost on anyone when you look at this map. This is not a Chuck E. Cheese at 5 p.m. This is a residence that means nothing to anybody but him. And it's not just a residence that means something to him, it's that residence at 5 a.m., which would be suspicious in and of itself, except that a young man is dead. And all 4 people were there that night at the same time. What are the odds? Unimaginable that those 4 phones are at that place in a 21-minute time frame. It is not plausible, except that exactly what the witnesses in this case said happened, and that Bestman Okafor went in that house that night and murdered Alex Zaldivar. Which brings us to the last piece of evidence that gives you confidence that he is responsible, and that is motive. Because 2 people on the morning of September 10th had motive to end 3 lives. One of them was locked up, and the other one is sitting in this courtroom today. Because the next day, he was set to face his accusers who saw his face, who knew who he was, and were going to give in great detail how he pulled them or attempted to pull them out of their house at gunpoint. He had the motive. According to the text messages on September 10th, Okafor knew his only way out was to make sure they didn't show up. Unfortunately, he only succeeded with 1. Now, all of that evidence goes to show the second thing the state has to prove with first-degree murder, which is that the defendant's criminal act caused the death of Alex Zaldivar. The third element the state has to prove first-degree murder is premeditation. The judge is going to instruct you on premeditation. I try not to read to adults, so I'm going to let you read it in front of you. That is the definition the judge will read to you and you will take back in the jury room with you. And during jury selection, I ask all of you to put aside what you thought you knew the law was on premeditation and listen as the judge instructs it. Consciously killing after deciding to do so, present in the mind at the time of the killing, there is no fixed period. The law does not require an intricate plan to bring about someone's death. Now, we have that here, but it can be as simple as a mosquito. Summer in Florida, you're sitting on the porch, you look down and you have a mosquito on your arm. And you have a split second to decide. Do you brush it off or do you squash it? And that determination, that split second determination, conscious decision to squash it is all that's necessary under the law. But of course, we have so much more in this case, so let's talk about that. The text messages, which you've already seen from Antoine McLaren or to Antoine McLaren and Dory, tell us that Mr. Okafor was contemplating murdering these young people on the afternoon of September 9th, and possibly long before. But the afternoon of September 9th is fine because he wanted a hoodie and gloves, which, by the way, further establishes, as most of this premeditation evidence does, his identification, because we know he was the one who learned from his mistake. We know Bestman Okafor was the man behind the T-shirts because last time he didn't have anything on his face. And he wasn't going to make the same mistake twice, not with Brianna Campos. So this time he covered his face. And the fact that he used T-shirts further establishes it's him because he didn't have a hoodie, because Antoine McLaren wasn't going over there to be a part of the murder. So he covered it with what he had. And he covered his hands not with gloves from a hardware store, but with latex or rubber gloves that he could find. So the text messages establish the premeditation. Detective Michael testified that on September 9th, at just after 9 p.m., 8 hours before the murder, Bestman Okafor, or the phone associated with Bestman Okafor, conducted a search of how to remove gunshot residue. Folks, why search that specific topic unless you're going to fire a gun? And that's important because his intention on that morning was not to go and scare anyone. It was not to go and rile feathers or steal anything. He went there to end lives. And we know that because he specifically wanted to know how to get rid of the evidence of firing the weapon he had. Then there's the fact that Bestman Okafor assembled a crew to go with him. And I would say it this way. Think about how difficult it is to get 5 separate individuals, all in their 20s, together to do anything. It's not an easy task to accomplish. And we know Bestman Okafor was on the phone a lot that night, trying to pull that very thing off. Because there are 24 phone calls. 24 between 6 p.m. on September 9th up and through 5 minutes after the murder between Emmanuel Wallace, Donnell Godfrey, and Emmanuel Wallace and Bestman Okafor. Wallace and Godfrey trying to figure out how they're going to get together and get in Candace Ruffin's Impala, which was left for them by Bestman Okafor, and then meet up at the vacant house. Every step, every phone call, another conscious decision to bring about Alex Zaldivar's death. We know that there's evidence of premeditation because of the use of the gloves. You all saw the gloves that are in evidence. There was testimony from Detective Mareschi that they were found in the same Impala that went that night. And I would submit to you that most people do not carry a box of latex gloves around in their car unless they're surgeons or some other type of profession. And we know that he was in search of gloves because of the text messages, and the timing of the gloves is telling. Because recall the testimony from the witnesses, the victims, they didn't put the gloves on when they first went in the house. The gloves came on only before the shots were fired, because now Bestman Okafor was applying the knowledge he got from his previous search. The use of the gloves, obtaining the gloves, all showing his premeditated design to end Alex Zaldivar's life. The fact that they faked the robbery and went to the trouble at all to deflect from the fact that they were going to murder is further evidence of premeditation, because the testimony was after the victims got on the ground or were forced to the ground that is when the items were turned over. That is when the house was destroyed, because they knew what they were about to do, because he knew what he was about to do. And the final evidence, ladies and gentlemen, of premeditation comes from the mouth of Bestman Okafor. Hours before, he told Antoine McLaren, "I can't let them show up." There's not a more clear statement about what his intentions were for those young people that night, except for the one overheard by Remington and Brianna Campos as they lie waiting to die. Bestman Okafor's words clearly signaling his intention to end their life. All because they were going to come here and tell the truth. That is the testimony and evidence that you have heard in this case. Overwhelming evidence, not just that Alex Zaldivar is dead, but that Bestman Okafor brought it about and that he did it with a premeditated intent to kill him. You're going to receive an instruction about how you should weigh the evidence, and you're going to hear that you're supposed to make your decision not because you feel sorry for anyone or because of sympathy or you're angry at anyone. And I want to be absolutely clear. There is no way to divorce the tragedy and the testimony from Brianna and Remington Campos from this situation. You cannot sit and listen to them without having an emotion. As they describe what happened to them, how Bestman Okafor laid them down, and they had to sit and listen to their friend lose his life and lock eyes afterwards. You can't do that. But what you have to do, and what we are asking you to do, is simply make a decision based upon the facts that have been presented to you. And if you do that, we are confident that you will find Bestman Okafor guilty of first-degree murder of Alex Zaldivar, the attempted murders of Brianna and Remington Campos, and burglary armed with explosives. Thank you.
Folks, let me give you about a 5 to 10 minute break just to stretch your legs, grab a quick drink, and we'll come back in for the defense's closing argument. Okay? Please do not discuss the case. Leave your pads on your chairs.
All right, thank you.
Mr. Mosley, let me let you get set up with whatever you need, okay? I'm sorry? No, we're going to.
I like that.